Hi, welcome to the Basics of Immigration Law. I'm glad you're here. In our first lesson, we'll explore the sources of the law in immigration matters. Let's get started. I will begin with the U.S. Constitution. The U.S. Constitution is the supreme law of the United States. Some parts of the Constitution are often cited in immigration courts, such as the Fifth Amendment or Due Process Clause, which states that no person shall be deprived of life, liberty, or property without due process of law. Second, the 14th Amendment or Citizenship Clause, which states that all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States. And third, Article 6 of the Supremacy Clause, which states, "This Constitution and the laws of the United States shall be the supreme law of the land." Let's go over the Immigration and Nationality Act, or INA. It's the primary law governing U.S. immigration. It was established in 1952 and amended over time, and is codified in Title 8 of the U.S. Code called Aliens and Nationality. Now let's move on to the Code of Federal Regulations. The CFR interprets and defines U.S. immigration law. Title 22 of the CFR, called Foreign Relations, contains visa-related regulations. Chapter 1, Subchapter E governs visa operations. The CFR provides additional policy and procedural guidance. Let's get into the Foreign Affairs Manual. The FAM provides directives and guidance for the U.S. Department of State personnel. It is based on statutes, regulations, executive order, and presidential directives. Chapter 9 of FAM specifically deals with U.S. visa adjudication, both non-immigrant and immigrant. It helps consular officers make informed visa decisions. The USCIS Policy Manual is the official guide of the U.S. Citizenship and Immigration Services, which is usually referred to as USCIS. It provides comprehensive policy guidance for USCIS officers when making decisions on immigration benefits. The USCIS Policy Manual replaces previous policy memoranda, the Adjudicator's Field Manual, and other guidance documents. Let's go over the executive orders and presidential proclamations. They are official directives issued by the President of the United States to manage the operations of the federal government. In immigration law, they are often used to establish or modify government enforcement priorities, implement temporary bans, or direct agency actions. While not legislation, they carry the force of law within the executive branch and can significantly impact immigration policy. However, they must align with existing statutes and the Constitution and can be challenged in court if they overstep legal boundaries. Let's go over the Attorney General and BIA precedent decisions. The Attorney General and the Board of Immigration Appeals, BIA, can issue decisions that establish binding legal precedent in immigration cases. These decisions interpret immigration laws and must be followed by immigration judges and DHS officers nationwide unless overruled by a federal court. While BIA precedent decisions are the most common, the Attorney General can also directly intervene in cases and issue rulings that carry the same legal weight. Here's a brief recap of Lesson 1 to reinforce what we've learned so far. The U.S. Constitution is the law of the land. The Immigration and Nationality Act is the primary source of immigration law and is found in Title 8 of the U.S. Code. The relevant parts of the Code of Federal Regulations are found in Title 8 and 22. The Foreign Affairs Manual provides visa adjudication guidance. The USCIS Policy Manual provides much of the guidance needed to prepare an immigration application. The executive orders and presidential proclamations establish law enforcement priorities. And finally, the Attorney General and BIA can issue decisions with binding legal precedent. That wraps up this lesson on the sources of the immigration law. I'll see you in the next one. Thanks for watching.